Good morning. Welcome to the Court of Appeals. We have three cases we were here today. And the first case on the argument calendar today is Jackson Creek Marine versus State of Maryland. We'll hear from the appellant's attorney.
Good morning. May it please the court. My name is David Sump, and with Christopher Abel, we represent the state of Maryland today. This is a case regarding the constitutionality of the Shipowner Limitation of Liability Act of 1851 as it applies to the sovereign states of America.
I thought it was a case about waiver.
No waiver, Your Honor.
Isn't that what the issue is?
Well, I'm sure my opponents would love waiver to be the issue, Your Honor, but the actual claim that was filed in this case reserved and identified that there was no waiver of our right, the state's right, to have its case heard in its own court, in its own forum, in its own state, which was not happening here. So we would assert that there is no waiver in this case. And it's a 12B6 motion, so you can't imply a waiver. It has to be an absolute waiver. So we don't see a waiver issue here, Your Honor. So what this case is about is a tug owned by Jackson Creek Marine that pushed a barge into the Route 50 bridge over the Nanticoke River and did property damage to the bridge. The bridge damage was $3 million thereabouts. The state sent an invoice to the owner of Jackson Creek Marine.
So you're not a plaintiff in this case?
Your Honor?
You're not a plaintiff in this action?
We are not. We are a respondent to the petitioner's petition.
So it's all about this Limitations Act?
Yes, Your Honor. It is
They
about.
want to say it's limited to a certain amount. You said we don't belong in this court because we are state and we can be our own. But I said it's waiver because it doesn't sound like to me that's the issue we're up here on is they say, well, you waived this because you appeared in court. You filed an answer. And there's a case, what's that, it's the 1800 case? I'm on a different case. There's an old case, Clark versus Barnard from 1883. It sort of long ago established that by doing things kind of what they say you're doing, you waive your right to assert immunity. But
right.
Isn't that the issue? Or is there some other issue in this case?
Oh, no, there's a lot more issues than that, Your Honor.
But I mean, the focal issue here
right.
in this case, because it's their case, the plaintiff case, they want to be able to bring it. You say they shouldn't even be able to talk to you because you're a state.
That's right.
You have immunity.
That's right.
They say you waived it.
Right.
Isn't that the big issue in the case? Or is there another? Tell me the big issue then.
The big issue is whether Congress had a right to enact a statute that abridged the state of Maryland's right to pursue a tortfeasor for the property damage to the bridge.
That's the second. That's that section. What's it? F of that?
Yeah, Rule F of the supplemental amity rules. But let me address your first issue, Your Honor. I think we need to get rid of that.
Because I think that it seems to me it plays into one another.
There is a case called In Re American River Transportation that was decided in 2015 where the Eighth Circuit Court of Appeals said in order to move to dismiss an action in limitation, you must first appear and file a claim. So the obligation to file a claim was that the federal government found out about this obligation in the In Re American River Transportation case because in order to have standing to challenge the limitation, you must first appear and make a claim to establish your right to be in the limitation. So the usual rules for waiver, where if you agreed to appear in court without filing the 12B immediately, you might be viewed as waiving. That's not the case in limitation because limitation is a special unicorn type of action. This is just one instance of how a limitation action does not behave like other actions.
So the initial action, I'm sure my colleague's going to have a lot of questions for you, so you probably have to get ready. But the initial thing you're talking about, the claim that has to be filed, that would be Maryland.
Yes.
In state court.
So the limitation of liability.
Tell me, where would you file it?
So on our own court, we would file that action in state court for a negligence cause of action against a vessel owner for failing to pay the damages for the bridge.
That's not the claim you're talking about. That's what you want to do. You're talking about if you file the claim and you do that, you're talking about the claim in federal court in response to this action.
So when the petition is filed, Your Honor, the judge issues a decree that says anybody with an interzoner claim against the vessel owner must appear and make that claim in this court by a particular deadline.
You seem to change the word, right? So what it says is that you either have to show up and make a claim, or you have to forego your rights to a claim. Essentially, they make you show up. It's a hostage choice. Totally get that. Right? But they say that you must show up. Right? So you might imagine if they did tell you that you must show up, that would actually implicate your sovereign immunity. But the problem here is that, like the Supreme Court described in Hood, they're not making you show up. You've chosen to do so.
Yes, but does the Constitution allow Congress to create a system where the state is sitting there with that choice?
That's what happens in Hood, right?
Yes, it does.
And the Supreme Court says exactly that. Right? It says, listen, you've got the choice. You voluntarily showed up in the bankruptcy proceeding, right? And there's, in that case, unlike this one, there was an actual summons that's issued. The court says it doesn't matter, right? Because you have the choice of whether to participate or not. And you have the choice here whether to participate or not. And you know, yeah, that's a tough place for Maryland to be. But at the same time, to me, this one's pretty clear that we have a sovereign immunity issue at all. Sovereign immunity is simply not implicated here. So we don't have to worry about waiver or abrogation or anything else. There is no sovereign immunity problem to talk about.
Yes, there is. Because the bankruptcy cause of action is not a limitation cause of action.
Okay, and Tuesday is not Thursday. Tell me why in the world that makes a big difference. They're both examples where the court is giving you, the state, the option to show up or not. And whether you show up or not, you do not have to pay any money. You are not paying any money. The course of the great state of Maryland is not having to pay money out. Might affect money you get in the future, but that was good, right? It says that doesn't matter. The fact that you're put in this hostage choice, right, as in Hood, doesn't make a difference. There is no sovereign immunity. That's the point of Hood. I take it here. You don't address Hood in the briefing, but that seems to be the problem that I see.
Section 106 of the Bankruptcy Code identifies all the sections of the Bankruptcy Code that implicate the sovereign rights of states. It has been determined that the bankruptcy clause of the Constitution is basically a waiver of sovereign immunity by the states when the bankruptcy clause was created.
So that's non-responsive, right? So that might help us if we're talking about cats. Right? Cats talks about when sovereign immunity is implicated and abrogated. Totally understand 106 of cats. Doesn't do anything with Hood, because what Hood tells us is that this process doesn't implicate sovereign immunity. It's not an abrogation. It's not Congress's power. It's simply not implicated. It's the state of Maryland's sovereign immunity. That's what Hood tells us in contrast with cats.
Correct. So if you only want to interpret this case as an 11th Amendment case, and if you only want to look at this case whether or not this is an abrogation permitted or not permitted by the 11th Amendment, that might be correct. But
well, first of all, it's not an 11th Amendment case, right? It's a sovereign immunity case. I'm telling you, I don't think there's an abrogation here, because I don't think your sovereign immunity is implicated. I don't understand how that framing is responsive in either way.
okay,
Right? The 11th Amendment is under-inclusive of sovereign immunity. Right? Abrogation of criminal trial system, in my view, simply irrelevant.
right. So if we were to agree that this isn't an 11th Amendment case, that we can't make the test to satisfy the 11th Amendment to protect the state of Maryland. Maryland has other sovereign rights beyond the 11th Amendment. The 10th Amendment says any rights that have not been granted to the federal government are retained by the states. And what we're looking at here is, did Congress have a right to interfere with Maryland's right to recover on this invoice? Did the Congress have a right when they wrote that statute in 1851? They didn't have authority, forget the 11th Amendment, just under 10th Amendment.
Just so I understand what you're saying, when you say, what distinction you're drawing between the 10th and the 11th Amendment? So sometimes we use the words 11th Amendment to describe sovereign immunity more broadly. Right, the 11th Amendment's responsivism, at times, the 11th Amendment doesn't encompass the full scope of sovereign immunity. That's why I don't use the term 11th Amendment. I'm talking about sovereign immunity. Are you making a claim separate from sovereign immunity? There's a separate 10th Amendment or independent of the doctrine of sovereign immunity?
Yes. The 10th Amendment is more expansive, but if I could go back to...
So can you start in your brief where you make a 10th Amendment argument that's independent from sovereign immunity?
We cite to the case of the City of New York versus Milne, which is an 1837 case, where the Supreme Court decided, looked at the panoply of rights that a state has independent of the federal government, including administering its highways, its bridges, and the other internal workings of that state.
Nobody doubts that you have those rights.
Right, so the question then becomes...
You can fix the bridge, right? If they knock the bridge down, you can fix it. I totally get it. You got an array of police powers.
Right.
Right? But I don't see what that's got anything to do with what we're talking about.
This
The question
talking
is
about-
whether the federal government has the authority to enact this statute.
Yes. And the question is, and if you look at the case of FMC versus South Carolina State Ports Authorities, you must uphold the dignity of the state sovereignty. And in that case, this court, the Fourth Circuit, and then affirmed by the Supreme Court, determined that that a complaint could not be adjudicated against a state by the FMC because that insulted the dignity of a state. This is no different. Telling a state that they cannot pursue or could have their entire claim compromised by a statute that doesn't even mention states.
And so your view is that this, like, Hood is wrong. Like, the Supreme Court in its set of cases is just wrong because all of those cases similarly, as you would claim, impugn the dignity of states.
Right, but again, I would indicate to you that I think that a bankruptcy case lies on different footing than this case does. And you have to remember that for 150 years, no one implicated the state's rights in the administration of the Limitation of Liability Act. It took 150 years before the 11th Circuit.
Why does that matter? Right? I mean, the point of this, I don't understand why that makes a difference, and I still don't understand why the bankruptcy code is different, and then I'll stop and let my colleagues ask questions. But maybe go back to the bankruptcy code for a second.
Sure.
So if in Hood the court says that this simply doesn't implicate a state's sovereign immunity, which is what the court said in Hood,
Right.
why does the nature of bankruptcy matter? It's not abrogation. The nature of bankruptcy might matter if we're talking about abrogation, right? That's cats. But in Hood, the court's at the threshold saying this simply doesn't implicate your sovereign immunity at all. We don't have to worry about whether we're overcoming it or abrogating it. It's not implicated.
Yes, Your Honor. And I would assert that a bankruptcy litigation is different than the Limitation of Liability Act. And the state does have rights that are implicated when a claim against a tortfeasor can be reduced to zero by virtue of a congressional statute that says the limitation fund equals the value of the vessel after the casualty. And I think FMC is really more on point than Hood is when evaluating the implications of the state's rights and whether a state should be forced to answer for limitation action that is intended solely to...
But I thought we've said already, you agreed that you're not forced to answer. You made a choice to answer.
Yes, it's the Hobbesian choice that
You're given the choice.
That's right, and it violates the dignity and the rights of a state to be forced to appear in court. Either you come to court and you assert your claim, or it's defaulted by the court. There's a default order that says you may never recover on this claim. And the question is, where is the authority of Congress to have drafted and implemented that statute when in fact there is no reference to states and how it could ever be applied to states. And it wasn't until the Bouchard versus Undergraf decision in 1998 that a court ever applied the Limitation of Liability Act to a state.
Well, that's the focal issue in this case that I think you focused on with Judge Richardson, is that you're saying this doesn't apply to a state at all.
No.
And that the state should be able to go into federal state court, your own court, as you say, bring your negligence action. You shouldn't have the federal courts coming up saying, well, we're going to limit the damage you get from the beginning. Well, why don't we hear from the other side, and then we'll come back, and I'm sure there'll be additional questions for you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Marisa Henderson, counsel for Jackson Creek Marine. I'm here with my law partner, Dave Ventker. And the court has already posed a number of very interesting questions, so I'm not sure if I should start with waiver or if I should start with Judge Richardson's arguments.
Always start in the middle.
All right, Judge Wynn. All right, let's go with waiver. I think there is a decent argument that the state has, in fact, waived its right to argue that its sovereign immunity is implicated here. And although it was forced to file a claim and answer, let's take a look at that claim and answer. That claim that the state filed actually invokes the court's admiralty jurisdiction under Rule 9H, which is kind of a special thing.
Is it your view that the state of Maryland could raise a constitutional challenge to the action without making some sort of an appearance? I mean, I understand
Good question.
Your briefing seemed to focus on the manner in which they answered, and I understand that argument. But at the threshold question, I take your colleague's position to be, not to put words in his mouth, is like, we can't challenge it without being in it in some sense.
So that raises an interesting question, because this actually happened in the Eastern District of Virginia in 2000.
I understand, but I'm asking whether you think.
Oh, I'm sorry, I'm getting there.
Is your view that just the mere act of saying we have an interest and we want to challenge the constitutionality, that is sufficient to amount to waiver? So what they have to do instead is what?
So the VDOT came into the Eastern District of Virginia in a limitation action, and before filing a claim and answer, it filed a motion to dismiss on sovereign immunity grounds. So that's the American Bridge case, and that probably is not a waiver, because they didn't make a general appearance. They said, hey,
So why if I'm the district court, like, why do I let a non-party show up and move to dismiss an action that they're not a part of?
I haven't looked at the underlying pleadings,
Like,
but
that seems particularly odd, right? We think in personal jurisdiction cases, in most cases, right, you got to be served before you file a motion to dismiss,
right.
even based on, jurisdictional grounds. I mean, it seems odd to say, like, that even before you're a part of the case in any sense, you've got to do something. And I don't know what mechanism exists to, like, force a non-party to move to dismiss when they're not even part of the action.
All I can say is that there were ways that Maryland could have protected its right and prevented a waiver, and it did not do that.
At JA 34, in the state of Maryland's answer, there does seem to be a disclaimer and a preservation
Yes.
of the rights of the state. It says that the answer did not constitute a waiver of its right to litigate damages in any forum and at a later time of its choosing, which right Maryland specifically reserves. That seems to be a preservation.
It is a preservation to argue in a different forum. So, for example, they could have stipulated to the value, or to the limitation fund and gone to a different forum. But I submit it's not a full waiver, a full preservation of the sovereign immunity right, because for the page before on JA 33, paragraph 5, they affirmatively assert the court's jurisdiction under Rule 9H, and they state, This claim is an admiralty and maritime claim within the jurisdiction of this court under 28 U.S.C. 1333, Federal Rule of Civil Procedure 9H, and Supplemental Admiralty Rule Procedure F5. And 9H
But
is
that's totally true, right? That's not inconsistent with their claim of sovereign immunity. Their point is, this is an admiralty action, this is legitimate as it applies to everybody except for the state of Maryland.
Fair, and-
So it's not outside of the court's jurisdiction, it's just that they, I mean, you might guess, I've got questions about whether they're right about this, but their argument is not that the federal courts lack jurisdiction over any such act, but the federal courts can't hail them into court in such an action.
That's fair, and I would ask you to look at the Google case, which came out of the Fourth Circuit in 2024, which does talk about waiver, and in that case, this court said that because the state voluntarily entered into an antitrust suit, it could not then argue sovereign immunity with respect to a subpoena that was issued. And the language,
Wait, when you use the word, in that case, you said they entered into an antitrust suit.
filed suit, yes.
Right, so if they filed the suit, you can't complain
Fair,
about
yeah.
the suit, all right? So, but we don't think Maryland filed the suit, right? Your client filed the suit.
Yes, but they
Right,
filed
they're
a-
responding to the court's order, the
Right.
court's invitation to show up. It's like being a defendant, if you show up and say, yeah, you served me, but I want to assert that you lack personal jurisdiction, they can do that, right? They don't have to like wait until the judgment is entered and challenge the default judgment, right?
Right. But I would point out that in this case, Maryland not just came in and challenged jurisdiction. They came in, they fully litigated the case. We were at the end of discovery. They filed a motion for summary judgment on the merits. So there is more, arguably, by fully participating in the litigation, there is, at some point, there becomes a waiver because they're voluntarily litigating. But, Your Honors, I don't think it matters in the end because there is no abrogation of Maryland's sovereign rights. So you don't even really need to reach the waiver question, which is why we led in our briefs on the issues that there's no abrogation of the Maryland's rights. And I think the court exactly, Judge Richardson, you have it exactly right. Bankruptcy, the court in Hood taught us, shows us that bankruptcy analogy is completely applicable to a limitation action. In all substantive purposes, in order to decide this question.
The Maryland right you refer to, allude to, is that the 11th Amendment?
The 11th Amendment as interpreted by the Supreme Court. So the 11th Amendment doesn't establish sovereign immunity, but it does confirm it. And while there are broader rights, and the Supreme Court has regularly construed the 11th Amendment beyond the literal text.
Maryland would rather go to its own courts and seek this in Maryland courts for the usual actions of negligence, but now you ended up as a matter of admiralty in the federal court as a defensive action as opposed to the plaintiff's action. That's what really complicates this, and it seemed to indicate there are just not a lot of cases in which the state has been a defendant in these cases. Is that correct?
Honestly, Your Honor, I don't know that there are not a lot of cases in which the state has been a defendant, but there are not a lot of cases in which the state has challenged that they had to even be in a limitation
Depends
action.
on how much the damages are. I mean, if you had a boat worth $2 billion and the bridge is worth $500,000, you're probably not going to contest that the limitation is $2 billion.
In fact,
But
yeah.
in this instance, where you got an amount that's way in excess of what the limitation is being assessed, what they are saying is that the federal government has no business coming in and telling them they can't get something, and even the statute itself doesn't name them as, parties that would be a party because they are independent, they are sovereign, just like the United States is.
And there's a couple of ways to look at the answer to that question. First of all, it's the supremacy clause, right? This is a validly issued a congressional statute. So it should apply equally to states as with other citizens unless the state has a sovereign immunity right. But the court has told us in Hood and other contexts that there can be instances in which the state's coffers are affected and their claims are reduced, such as in bankruptcy, and it is not a violation of a state's rights under sovereign immunity because...
Do we have to find that that was what Congress intended in enacting the Limitation Act? It does seem unfair that the taxpayers of the state of Maryland will be on the hook for a repair that's $3 million without any ability to seek recovery.
It would only matter if there was an abrogation of sovereign immunity, in which case you would need to find a clear statement of congressional intent. But we believe that because there is no offensive claim against the state, let's go back to the language of the 11th Amendment, then there is no abrogation of sovereign immunity, in which case you don't need a clear statement. I don't think Congress would even consider that there could be an abrogation of a state's sovereign immunity in this case, so there doesn't need to be a clear statement. And if you look back at the text of the 11th Amendment, it talks about the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States. There is no suit commenced or prosecuted against Maryland. In fact, every court that has considered this issue, 2 circuit courts and 3 district courts, have found, in fact, that Maryland's claims are of sovereign immunity, that they're not valid. And that's, again, because there's no affirmative action. Jackson Creek Marine, our client, is not trying to get anything from the state. We're not trying to get money. We're not trying to get anything from them. So therefore, there is no offensive action. And like I said, the 10th Circuit in the Magnolia Marine Transport case, the 11th Circuit in the Bouchard case, Eastern District of Virginia twice now, Southern District of Florida, and Eastern District of Louisiana have all rejected all the claims and all the arguments that are made by Maryland today. I did want on my...
Is your colleague going to pick up where you are right now?
I hope so, Your Honor.
Why don't you let your colleague go? Oh, you can just borrow some of her time if you want to.
If she'll let me.
Good morning. May it please the court, Sophia Shams on behalf of the United States. As the discussion today here have reflected, a limitation proceeding is one that is defensive in nature. A court's role in this context is just to determine whether a ship owner is entitled to a limitation of his damages. And for that reason, it's sufficiently analogous to a bankruptcy proceeding, and sovereign immunity does not apply. 2 circuits have held as much, and there's no need to create a circuit split here. For that reason,
Is Maryland being hailed into court here?
Your Honor, Maryland is not being hailed into court here.
What's the choice it has?
The choice it has is what this court recognized in Antonelli Creditors, in Re Collins, and as well as what the Supreme Court has recognized in Hood, which is that Maryland has a choice to file its claim to get proceeds from the limitation fund, or Maryland can forego its claim in this context. But Maryland is not being issued any sort of summons. It's not being required to go into court. It's not being named as a defendant. And these are
So
all...
to file a claim to get from the limitations fund means that they cannot go any higher, I guess in this instance, than the $900,000.
That's correct, Your Honor, that they would not...
Does Maryland have a choice that allows it to pursue the full $3+ million?
Not in this context, Your Honor. It does not. And that's
So
precise...
Maryland has been foreclosed from getting damages from a private entity, a ship owner, whatever, that drives into his bridge, causes $3 million worth of damages. If nothing was done, in other words, if your client, or not your client, but Jackson Creek had done nothing, then they could go into state court and maybe get a judgment, $3 million, recover. But because this intervenes, or want of a better term, but this comes into play, this is a limitation action. You said, well, they're not a plaintiff, but they are, because they want $3 million, not $900,000, but they can't get that $3 million if they don't find some way to get in and argue the constitutionality of having them in court, or some way in which they can challenge, you don't have a right to tell the state of Maryland that we can only get this amount of money.
Your Honor, the limitation proceeding provides exclusive jurisdiction in this context to federal court, just like Section 1333 of the U.S. Code does for certain admiralty proceedings. And I don't think any party in this case is arguing that that provision is unconstitutional. I think courts around the country, as well as the Supreme Court, have recognized Congress's unique role in issuing statutes with respect to admiralty, and that federal courts
What's
have...
the procedure route of which Rule F came about? It was, you had it in 1883, the Clark case, then you saw the problem of venue and location, and
Sure.
there was a Supreme Court case that sort
Norway.
of drove this.
Your Honor, the Supreme Court's decision in Norwich did establish some of the procedures for Rule F, but the right to a limitation of a vessel in and of itself was established by Congress in the Limitation and Liability Act under Section 3523 and 3529. And so
Can I ask a follow-up question to that? If the Limitation Act was never filed, so if they just never filed such an action, and
Sure.
the state of Maryland instead filed an action in the State Court of Maryland?
Yes.
Which, absent a Limitation Act, they would be entitled to do, would the Limitation Act's cap on damages apply in the state court action too?
I think it could, because Section 3523 provides generally for a limitation of liability in these contexts. And I think it's also important to recognize that there might still be removal to federal court under Section 1333, which provides federal courts with admiralty jurisdiction. So I think there are contexts in which we would still be in federal court in this case.
So you're saying it could be filed in state court, and then an affirmative defense is brought by Jackson Creek in state court, I guess, to say that the Limitations Act limit the amount we pay. Is it then the state court can then act under this federal statute, or do they then have to, once the judgment comes out, institute this Limitations Act under this section, Rule
Right.
F, in federal court?
Right, so let me clarify. I think in that context of which a state court proceeding is already initiated, which this has not happened in this case because Maryland has not done so, but in that context, there could be a limitation defense and it could be removed to federal court in that context because the act provides federal courts with exclusive jurisdiction. But in a case like this, and under the venue procedures, under that case, they would have to file, the ship owner would have to file in a federal court in that state. But in a
now,
case
let me
like this,
understand. If you're looking at the section 3523, that basically establishes a limitation.
it
And
establishes
it
a
doesn't
right.
tell you which court you have to go in.
Sure.
And but the proceedings, I suppose, could be heard in any court.
Any federal court, sure.
But the limitation part is the federal court. Is that right?
The limitation part should be heard in federal court. That is what Congress provided for. And I wanna emphasize that what Maryland's arguing today is essentially a contestation of venue, right? So they're arguing that they shouldn't be held in a particular federal court. But the problem is that these types of venue claims have been rejected in the bankruptcy context. They've been rejected by the federal circuit in the patent context. And in this type of case, Maryland is simply not acting as a defendant.
So here's the odd thing. You got an accident that occurred. No one has assessed liability one way or the other, and you come into federal court, says, I want to be limited to 900,000 damages, but potentially you could be found not negligent, not owing anything. Does that obligate you then to pay the 900,000? Even if you go into federal court, are you basically conceding liability for up to that amount?
Your Honor, I think the action in federal court, what it does is it initiates a proceeding to determine your liability. And so in order to make that liability determination, the court does have to look at whether the act would be implicated. So for example, whether there's a finding of negligence as Maryland has alleged in this case. If that's the case, then the Limitation Liability Act kicks into action, and a ship owner is entitled to a limitation of his damages, which means Maryland can only collect up to $900,000. The court's role at that point is to allocate the fund accordingly to all claimants. And so in this case, Maryland might be the only claimant, but the purpose of this act is to streamline claims into a single court, just like in a bankruptcy proceeding, and ensure that claimants are given their due as well as a vessel owner is given their right to diminish their
How
liability.
does Maryland protect itself? You've got ships out there. If you got a ship out there, let's say worth $500,000, it runs into a tunnel or bridge that's worth $500 million or whatever. You're telling me Maryland cannot keep these vessels from coming in if they don't say, can Maryland say, you're not gonna drive your ship through here, because if you hit my bridge and tear this bridge up, I'm gonna have to pay for it, and all you give me is the value of this ship. Can they prohibit them from coming in?
I'm not sure the actions Maryland can take to wholesale prohibit ships from coming in, but what I do know.
Typically, we don't allow states to interfere with the navigation of the waters of the United States. That'd be a highly unusual thing for a state to be permitted to do.
Certainly, but I'm not prepared to talk about one way or the other, whether.
The question is really not as to, I understand, being a Navy guy myself, navigation is free. I'm talking about liability. Do you get to navigate something that can cause, or for which your liability for where you're going can cause excessive damages, and a statute now limits? Maryland says, I don't care if it costs $10 million to fix that bridge over there. That ship is only worth $50,000. That's all you're gonna get. And it can't tell ships that for $50,000, you can't go by my expensive bridge up here. Maybe provide an alternate way. There's none of that that's there.
I'm not entirely sure what the state could do in this context, but Your Honor, 2 points I want to make that I think address your concern. First, in the bankruptcy context, a state is entitled to certain debts from a debtor, and this court has recognized and the Supreme Court has recognized that the fact that the state may lose out on that judgment or may forego its claim altogether is not enough for sovereign immunity to be implicated. And second, the purpose of this act, which the Supreme Court has recognized in Norwick and cases thereafter, is to provide protection to ship owners in order to promote maritime commerce. It is a long-standing common law practice, and we have a long-standing tradition of Congress regulating in this realm. And so I don't think that the underlying concerns of the state, while they are serious and we recognize that, are enough to implicate their sovereign immunity claims. Congress was well within its power to enact an admiralty statute of this nature. The Supreme Court has recognized in similar proceedings like bankruptcy, and this court has likewise done as well, that these types of proceedings just do not implicate sovereign immunity. And 2 circuits, as well as federal district courts, have recognized as much as well. There's simply no need to create a circuit split in this context where there is a streamlined process for resolving claims. For that reason, we ask you to affirm the district court's dismissal. Thank you.
Thank you very much. All right, Mr. Sump, we will hear back from you.
Thank you, Your Honor. If I might, when looking at the difference between limitation and bankruptcy cases and the treasurer salvage cases, the difference is the process and procedure. Treasure cases and bankruptcy cases are in rem cases where the bankruptcy estate is the corpus, it is the race. All of the parties that are appearing in bankruptcy court are making claims against a corpus for which it is finite. There is only this. Isn't
that exactly sort of what we're doing here, right? That in some sense what Jackson Marine is saying is like, it's a form almost of interpleader, right? That sort of says like, here's $900,000. If we're responsible, like you get to divvy it up. We're not conceding liability maybe, but in effect, it's just like a bankruptcy proceeding, right? There's a cap that's determined by the court, right? Based on the value, the court's got to do some work to know that. But that seems like a bankruptcy in rem proceeding to me.
But it's not. It is not.
Yeah, but why? But why is it different in a material way?
It is different in a material way because if the vessel owner cannot satisfy the requirements to limit liability, they are liable for the entire claim. So this isn't a finite amount of property.
And in Hood, the same thing, right? So if you don't make the undue hardship showing,
right,
then the individual was liable for the entire amount, right? So that's exactly the case in Hood, right? That distinction is literally the case in Hood.
Except for the fact that in Hood, you're looking at the bankruptcy estate and we're trying to recover and claw back, right, for the hardship.
No, it's not a clawback, right? The question is whether that debt, which was owed to the state, was discharged.
Right.
And in order for it to be discharged, the individual had to make an undue hardship showing.
Right.
And the state said that infringes our sovereign immunity, and the Supreme Court's like, not even close.
So, again, the bankruptcy scenario isn't the same as a limitation of liability X scenario. They are not based on the same law. They are not based on the same jurisdiction. These are in personam claims.
Okay, but why does the jurisdiction's different? One's bankruptcy and one's admiralty.
Right.
Both seem to go back a long way. They seem to be sort of important parts of our nation's history.
Okay.
So why do we think about admiralty as being, some second class process that like doesn't really matter, but bankruptcy, that's super important, right? I mean, my good friend here to the left spent some time on the water, right? Like those are important issues.
Right. So the difference is that the bankruptcy is dealing, and the in rem treasure salvage cases are dealing with a claim to a race. And the race is the jurisdictional basis of the claim. Admiralty law, there is an admiralty clause to the Constitution that says everything that was within the common law of the admiralty jurisdiction at the time the Constitution was created carries over into the Constitution. This is not that. This was created in 1851. It's not part of the common law of admiralty. This is a statutory creation.
Admiralty at the founding didn't address shipwrecks?
It addressed shipwrecks, but not limitation of liability. That is clearly a statutory creation. Our country existed for 60, 70 years before there was a ship owner limitation of liability act. It didn't exist at all.
Wait, but so your position is that because there was not this act before? Like the whole
Right.
point of admiralty is that the U.S. government has the authority of a scope that matches the common law.
Correct.
Right? So the common law obviously addressed liability stemming from
Sure.
shipwrecks. Right? This is a statutory enactment that does exactly the same thing. It addresses liability from shipwrecks. It is like plainly within the admiralty power of Congress
It is,
to enact. Now, you want to say not that they couldn't enact it as against private parties. You think it doesn't apply as against states, but your argument here is to suggest that they didn't have the authority to enact it at all. That seems like a wild claim.
We're looking for a waiver of sovereign immunity or a waiver of states' rights. That's what we're looking for. The admiralty clause of the Constitution doesn't provide that.
Only if it implicates the sovereign immunity of the state do we need to find a waiver, right?
Yes, Your Honor.
Judge. Thank you very much. Thank both of you for your very able arguments. The court is going to come down and greet counsel and return to the bench for the second case of the day.
Three core arguments. First, that Mr. Ozarumba's forced cooking did not constitute material support because it was neither relevant nor significant to terrorism. Second, that Mr. Ozarumba's actions did not constitute material support because they were done under duress. And third, that the BIA made multiple errors in its CAT analysis. I plan on focusing the bulk of my time, Your Honors, on those first two arguments, and I'd like to begin by discussing materiality. Fundamental principles of statutory interpretation demand that the word material must mean something.
Can I just ask the threshold question and then
Yeah, sure.
you can come back to this? Does the second question inform the first, right? Because seems to be a period of time that was voluntary, that was small, and then there's a longer period that you allege is under duress. It seems a little hard for me to think about the first question without sort of an answer to the second question. I'm happy for you to go in any order, but do you agree that that's, like, as a framing matter, if we reject your duress argument, that your material argument becomes much harder?
I don't necessarily think it in that order, and because the materiality argument, even if the court disagrees with the duress argument, and Mr. Rosenrumba's actions never constitute material support, it never constituted material support regardless of the duress question. And so to your second point about whether that first bit was material, or sorry, the first bit was voluntary as opposed to that second bit being duress, Your Honor, that question is important because at all relevant times, Mr. Rosenrumba was acting duress. And I say relevant because prior to his becoming aware of the nature of the organization, he wasn't covered by the statute at all. This is because Tier 3 terrorist organizations like the Unknown Gunman here the material support bar has an explicit knowing requirement. So Mr. Rosenrumba did not know the nature of the organization and when he started working at the camp, and once he found out, at that point his actions became under duress. So that first question, that first bit, Your Honor, is covered by that knowing requirement in the statute, Your Honor.
So you think that these questions are really alternative, they're not sort of in conjunction?
Yes, Your Honor. If Mr. Rosenrumba support or actions did not constitute material support, then he's not covered by the bar, Your Honor. Or if the court finds that Mr. Rosenrumba's actions were material, but they were done under duress, also his actions did not satisfy the bar.
I'll stop. I just want to understand the framework. And so the question of when I'm trying to answer this question of materiality, you would have me look at the entire time period that he cooked for the organization, and the question is whether that is material. And if so, then I answer the second question. Is the fact that you allege that portion was under duress takes that out?
Yes, Your Honor.
But okay, thank you.
Yes, of course, thank you, Your Honor. And so, although the precise meaning of the word material always depends on its context, the word always has the effect of raising the threshold of the word it modifies. And so based on the context here, based on the definition of the word material, based on the list of illustrative examples given in the statute, mere support becomes material support when it is both significant and relevant to terrorism. As this court has held, support can be significant when it is sufficiently substantial standing alone to have an effect on the ability of the organization to accomplish its goals. Support can also be significant when it gives legitimacy to the organization.
Can you address our decision in Villegas?
Yes, sir.
Because the court seems, I understand there are other places, you keep using the word significant. Villegas seems to sort of set the bar like quite a bit lower, sort of saying, he paid, a couple of dollars and like put up posters, and that was material. Can you put it in that framework for me?
Yes, Your Honor.
I mean, this seems like, the point being is that we talk about very small amounts of things, but over a extended period of time, which is, I think, the issue we have here. I'm cooking every day, but I'm doing it over the course of a number of months or years. Why am I not thinking about this in the same way as that?
No, Your Honor, we absolutely agree that this court should apply Villegas. Villegas is an important part of this area, but I do think that sufficiently substantial standing alone sort of piece of it gets to that significance aspect. Significantly substantial standing alone does raise a threshold here. And so in Villegas, you're also, and so we absolutely say that is an important part of the test that this court should absolutely apply. And then Mr. Rosenrumba's actions don't satisfy that here. And the distinction between this and Villegas, as we acknowledge that Villegas was about money and about hanging flyers. And several courts have held that the act of hanging flyers is very important to a terrorist organization because it helps with recruiting. That was the case in Hosseini. That was the case in, I think, a Seventh Circuit case called Khan, Your Honor. That act itself has been held to be quite important. And when it comes to funds, based on the construction of the statute and that second use of the word material, we do concede, as I believe we have to, as in the Ninth Circuit held, the 11th Circuit held, that funds are material. And so that is the distinction here between what we're talking about with Villegas.
What about the words transportation and communication in the statute? On their face, they seem to be broad and not connected to weapons or funds. but they're just broad support. So why isn't cooking like those, like providing that kind of material support?
Thank you, Your Honor. Those examples certainly can be used. And I think it's important to apply a sort of an individual analysis here of whether this individual actually engaged in material support. So to take those, to take communications, for example, communications certainly can be material support. If someone, for instance, is on a radio providing real-time targeting information to support a terrorist attack, that is undoubtedly material to terrorism. But what about let's say the telecom company, Your Honor, providing cellular coverage and knowingly providing cellular coverage in an area where terrorists operate? I don't think we think of that as categorically being material. It requires an analysis and running it through. Is it actually material? Or to take transportation, for example. Transportation certainly can be highly relevant to terrorism. For example, a getaway driver. But take another example. What about the bus driver for the regional bus service? If a part of his ordinary bus route he picks up and someone boards the bus that is a known terrorist and he doesn't kick him off the bus, has he categorically provided material support to terrorism? And I think the answer has to be no here. I think both the statutory construction by the framing of material, Your Honor, demands that the discrete act itself be individually analyzed. And even training, Your Honors, gets to that question. I mean, training, weapons training is unquestionably material support. But what about, to just take a hypothetical, the terrorist who decides they want music lessons? Is the person they hire to give training for piano lessons providing categorical material support to terrorism? We think the answer, Your Honors, has to be no, and it's because the word material is doing work here. It's because the word material has an important significance and relevance aspects. That's the through line dividing those lines between those examples, Your Honor. And so here with Mr. Ozurumba, to take his example, he prepared food for the camp's leaders. He did so alongside several other cooks who cooked for the rest of the camp. Under the government's characterization, Mr. Ozurumba's value to the organization was that he was able to cook recipes that the leaders liked and that the leaders preferred. But that resource, that discrete act of support, the quality of his cooking, is immaterial to terrorism, Your Honor, much like the bus driver.
There's a statutory text here, and we have, in cases like Villegas and a number of other cases, relied upon review on the Chevron deference there. Well, Loper Bright, the Supreme Court case, got rid of Chevron deference.
Yes, Your Honor.
But there remains the question, first, going forward, do we just apply the Skidmore deference, which I think is probably the direction to go. But the more important question is, what's the value of those cases that applied Chevron deference, like Vegas, in terms of looking at this statute? Do we, on our own now, forego that and look at this statute? This is where we get into the question of materiality and relevance and significance, which goes beyond those cases because those cases relied upon Chevron deference.
Yes, sir.
The implications of getting rid of things like Chevron deference is far longer than saying maybe for the future. I don't know. But if it relied upon it, and that's the basis upon what that text we're now looking at, what do we do here? And so I think that's, it still goes to the ultimate question, is this material? I mean, is this cooking like communication, is like transportation, that sort of thing? But the question that you, fundamentally, the first thing to deal with is where are we? What are we limited by? Are we limited by those Chevron deference cases, or are we now in a more of a de novo, or at least we are in a review of the statute, and without this limitation, maybe a Skidmore deference limitation or others, which some people say Skidmore is not even Skidmore. I don't know what it is, but I think that needs to be addressed first to know what we can do, because I think before Loper Bright, we are definitely limited by the Chevron deference cases. May still be, because I'm not sure the retroactivity applies to those to getting rid of the stare decisis effects of those early cases.
Yes, right. Just to be precise, you're asking about Villegas and Barahona, not the agency opinion. Or are you also asking about
any case in which we are to look upon the stare decisis that relied upon Chevron deference for the basis of its holding, to what extent are we now to follow those statutory interpretations that were rendered as a result of looking at Chevron deference?
Understood, Your Honor. So Those cases are not binding because this court is reviewing new agency action. The agency has since acted, and since this court has applied its Chevron deference. So, and it's important, this.
But how is that consistent with our recent decision in Chavez versus Bondi? The chief wrote an opinion that sort of seems to like fundamentally disagree with that, right? That sort of says, no, we maintain the results of those prior actions, so the statutory interpretation that took place continues to apply. That's what Loper Bright seems to say, but to the extent there's not clarity there, it seems like the chief's recent opinion sort of answers this question.
So I don't think necessarily it applies. So the precise question there is applying Chevron deference, at least that my reading of Chavez, Your Honor, gets to whether Skidmore is applied to the agency action itself. And there's two separate questions here. So there's this question of Skidmore, of whether this court should apply Skidmore deference to the agency opinion, and there's also the separate question of whether what value this court's prior opinions in Villegas and Barahona, and whether this court is bound by them. And they're not bound, and here's...
Well, but that's what Chavez says, is that we are bound, right? Like, I take Chavez as, I get the Skidmore question is a separate one in Chavez, but I take the chief's discussion there to say that Loper Bright doesn't wipe away the results. And if it doesn't wipe away the results, then prior panel decisions remain binding, right? If Loper Bright hasn't wiped them away, like, our rules tell us that we are bound by our prior decisions, right? Because we might think about the reasoning differently doesn't help. It has to be either overturned by the Supreme Court or so substantially undermined by the Supreme Court. And what Chavez tells us is Loper Bright doesn't undermine those cases.
Absolutely, Your Honor, and I absolutely agree with that, because it doesn't come from Loper Bright. It comes from Brand X, and it comes from this court's application of Brand X. This court has done this multiple times in this exact situation under the BIA. Under Fernandez v. Kiesler, Your Honor, the BIA issued an opinion. This court...
I'm sorry, so wait, just back me up a second. So your position is that our prior decisions that relied on Chevron were undermined by Brand X, and so therefore are not binding on us anymore?
No, I'm saying that this court, so to take the Fernandez example, the BIA issued an opinion. This court issued, or demonstrated Chevron deference and issued deference to that opinion. The BIA then acted again and changed its opinion. This court that was presented in Fernandez, the question specifically was whether to apply its previous precedent or whether to apply new Chevron deference to that second BIA opinion. And in Fernandez v. Kiesler, this court cited Brand X and specifically said that it needs to apply Chevron deference anew, or Chevron review anew, to that second action and not defer to its prior precedent.
Well, what you really need to get to is, yeah, Chevron said that, but it said we couldn't change the results. Didn't say it was correct. Couldn't be. I mean, when you think about it, it cannot be, as a matter of fact, correct. If the Supreme Court says we can't give deference to an agency's interpretation, and we have prior opinions that rest upon an agency's interpretation that we gave deference to, Supreme Court says that's not good because Chevron doesn't give you that anymore. The results could still be, as Judge Diaz pointed out, the right results. But it doesn't keep us from looking to see if that statute, we're not bound to go back to this agency's deference under Chevron. We cannot be. I mean, if we are, then I don't know, Chevron only applies to stuff that's going forward and not back. It doesn't seem to follow that we're stuck with a statutory interpretation that an agency made because we gave deference to it. Supreme Court says, no, you're not. So I'm not saying we can't use them for prior precedent or value, but their interpretation of a statute is something fundamentally, it seems, that is before us, because they wrongfully now, in the eyes of the Supreme Court, relied upon an agency's interpretation. That's the court's job, and we still have that job. But it may not change the result of your case at all. But in terms of how we view it, to just blindly say, well, we're going to rely on that case because it held this statute said that, and it relied upon Chevron deference to do so, Supreme Court said you cannot do that because it's giving this agency deference, which is your job, we give Skidmore. So, I mean, it may not be a difference at the end of the day for you, I can tell you that right now. But at least in terms of getting that right and making sure we articulate it is important for this case and other cases to understand how do we look at those previous cases that relied upon Chevron deference. But
Absolutely, Your Honor. I see I'm out of time. I'm happy to respond to that question if you'd like. I'm happy to pick it up on rebuttal, Your Honor.
you've got some time coming back.
Can I?
But go ahead,
Well,
Judge.
if you want to respond on the reply, will you add this to your response? Which is, does that same analysis apply now that the Supreme Court has told us we don't look at legislative history? So any Fourth Circuit decision that previously relied upon legislative history to reach a result now is no longer binding on a current panel of the Fourth Circuit? Is there a difference between the discredited reliance on an agency and the discredited reliance on legislative history, such that we should think about those two outcomes differently? Or in your view, do you think that the sort of discredited reliance on legislative history now means that any case that relied on legislative history is not good law, in the same way that any reliance on Chevron is no longer good law? Is
Understood,
there
Your
a
Honor.
difference?
I'm happy to take that up on rebuttal. Thank you, Your Honor.
Thank you, counsel.
Mr. Stone?
Good morning. May it please the court. My name is Paul Stone. I represent the respondent, Attorney General of the United States. The petitioner cooking meals 3 times a day, 7 days a week, over 6 months, 3 with pay and 3 without, for the 15 to 17 leaders of the unknown gunman terrorist organization is material support to that organization because it helps sustain it so it could engage in violent terrorist acts.
So the questions we've been going back and forth on is what is material support? And to what extent do we rely upon previous cases of this court? Judge Richardson has rightly pointed out the Chevron's case that indicates that we ought at least to look at the results of those prior cases that are there. And I'm only asking in terms of how to set this thing up from a jurisprudence perspective, how we deal with it, that fundamentally, are we now bound by cases? Is it your position we're bound by those cases that the court use Chevron deference, which is essentially we defer to the agency's interpretation of a statute? Court says, no, you don't do that. It's your job to interpret that statute. And Skidmore, I assume, is one of the ways, maybe there's an oral or whatever to do it too. The question, at least the initial question is, are we bound, not so much by the cases, we are bound by the cases, but by their statutory interpretation that was rendered through Chevron deference?
Well, our interpretation of Loper-Bright is that the court remains bound by its decisions, including the statutory interpretations, where the agency takes an inconsistent position, then obviously the statutory interpretation needs to happen again. For example, in this case, for example, MHZ, the board followed this court's interpretation of Barahona. And Barahona is also not your typical Chevron case.
So we had a case previously in which we said we're following this because of Chevron deference, and we said in opinion, but for Chevron deference, we would interpret this differently. You say we're still bound by that decision?
Under Loper-Bright, yes, but
Because we would have had to said, the first time, in order to rely on Chevron, we would have had to said, it's genuinely ambiguous
Correct,
at
Your
step 1, and therefore we defer at step 2.
Correct. And you're not stuck with the case, Your Honor, because it can be reversed en banc. It could be reversed by the Supreme Court. It could be reversed by statute. So, for example, in this case, should the court decide to follow Barahona, petitioner could file a petition for en banc rehearing or
But
the
it's,
Supreme Court.
and not to be, there's a difference. You're not reversing the case. You're saying we made that determination on the statutory interpretation based upon the agency's interpretation, and we gave it deference. We don't have to do that anymore. It would seem to me you don't have to give deference to that. That case, to the extent it relied on deference, that part about it, I don't think we are bound by that anymore. The case itself, and maybe the interpretation, the reasonableness of the whole bit under Skidmore, yes. But to say now we are bound by something an agency interpreted because we gave it deference, for which we no longer give you deference, is going to bound every future case now on that statute, doesn't seem to follow to me.
Well,
And it doesn't follow in the same vein as legislative history, because that's different. We're not talking about someone who made the determination for us. That's an independent determination of history. This is something an agency did that is done. If we had a case, if the Supreme Court said we had to rely upon an agency's determination of legislative history, and then said no, it doesn't seem to follow that once it says no, you don't have to do it. We're bound by those cases in which we defer to its interpretation of it. You see where I'm going with that? But it's, as I say, I think it sounds like semantics, but it really is getting to a fundamental question here is where are we? Because when we get into this statute, we could be severely limited by cases on what is material and you know, support and that sort of thing. And we are, to the extent those cases are consistent with the reasonable interpretation of the statute, but not to Chevron deference. That's my opinion.
Well, Your Honor, we're all struggling with this. It's a new world for all of us. But I think the Supreme Court in Loper Bright had its perspective on the reason that those cases may remain precedential is that the statutory interpretation becomes part of the statute for purposes of Congress amending it or altering or changing it. And so, for example, the Barahona decision has been on the books since, I think, 2012. And so it's been in front of Congress for over 10 years that there's no duress exception to this material support bar. So it hasn't made any legislative decisions based on what could be this entirely new decision. So I think the idea that it does retain some precedential value is in part because of that.
But you agree this is a new agency action here?
Yes, this is a new agency action.
That's
here.
that's where I'm getting at. Loper Bright did limit itself to say specific agent actions. This is a new agent action.
Well, our perspective is that, yes, this new agency action, MHZ, can absolutely be reviewed, but reviewed in light of the precedent set by Barahona.
But Loper Bright says that statutory stare decisis applies, right? Which means that's including statutory interpretation questions that were decided under Chevron.
Correct. So
Can we get back to your materiality definition? Because I find it troubling that there seem to be no limitations on the way you're looking at the word material. So, for example, I asked a similar question to your friend on the other side. If a worker cleans the home of a terrorist knowing that they're a terrorist, would that be material support under your definition? A cleaner, a dentist, providing dental services to a terrorist, would that be material support?
It might be. It depends on if the terrorist is a member of a terrorist organization, then it would fall under that.
Understood. So if a house cleaner cleaned a room, if a dentist provided dental services, if a taxi driver gave a ride, knowing that the individual was a terrorist and all of the other qualifications, that would be material support under your definition?
I can't answer those specific cases. It might be, but the fact of the matter is here, Congress has set up a deliberately extraordinarily broad definition, which is why it also has this equally extraordinarily broad
Would it depend upon, might it depend upon sort of the frequency with which it's done? So take somebody that cleans, the Paul who cleans my office back in Columbia, he gets security clearance and is able to sort of come in and out of our chambers in a particular way. And so his sort of cleaning of the office sort of seems like a little bit different in a sort of way that he might be providing material support to me.
Right.
Where to me personally, I don't mean a terrorist, I'm not a terrorist, but I'm not going to admit to that here at least. But maybe we wouldn't think about, if I just happened to hop in an Uber and the Uber driver knew that I was a judge, we might not say that the Uber driver provided material support in the same way that Paul does when he cleans my office because of his background check and the position of trust that someone cleaning a judge's office might hold.
Right. Well, yeah, ultimately the limitation is it has to to promote, sustain, or maintain the organization. So the question is, does that one-off actually help anything? One example is,
But the word material has to have a meaning. So there's two words, there's material and support. And materiality would have to have a meaning, modifying support, would it not?
It depends on how Congress enacts it. And here, Congress has enacted them as a phrase, material support, and then given examples.
And your
none of which
definition
have-
seems to render the word material modifying support meaningless. You're suggesting that every form of support is definitionally material support.
No, Your Honor, we're not. We're taking a different perspective, which is the petitioner's arguing that material means the support has to go to terrorism. We're saying it doesn't. The support is material if it goes to promoting, sustaining, or maintaining the organization. So something that doesn't promote, maintain, or sustain the organization is not material. The Seventh Circuit gave an example in, I believe it was their Cower case, where it talked about, attending a terrorist meeting would not promote, sustain, or it didn't use that particular language, but wouldn't be material
So the phone
support.
company providing a telephone line, it maintains the organization, is that material support?
A telephone company maintaining a telephone line for a terrorist organization?
To the camp?
Yes, certainly. I think that would be a fairly, an easier find there. But also, as petitioner's counsel pointed out, there does have to be knowledge element there. So for example, if it's just a telephone line to an unknown destination that happens to be a terrorist, then, whoever made the decision at the telephone company probably doesn't know that they're a terrorist or a terrorist organization, which is one of the requirements for material support. Congress defined material support with as I talked about, all of these examples, and none of which are quantitative, and they involve typically tangible things like house, transportation, or funds. And these examples are all quantitative, and a few courts have agreed with us. We cited them in our brief.
Do you think?
Hincapi
Do you
and
think
Ramaji.
for money, as an example, that there is an immaterial amount? We're talking now about getting rid of pennies, right? They're gonna stop printing them, but stay with me for a minute that I still have them in my pocket, right? If I happen to know that someone was a terrorist and I flipped them a penny, do you think that I would then have an argument to say that, like, whatever we want to say, like, that's an immaterial amount of money? And maybe, $2 a month for 2 years in a given country where the, wages are much different than they are here might feel material, but, a penny in a single instance might not be material. Is that a line that's at least feasible to draw?
I mean, if it doesn't promote, sustain, or maintain the organization, it is a line, but it does run into the Supreme Court's decision in HLP, which cited Congress's statement in the 1986 ADPA Act, where it said any support to an organization facilitates that organization's terrorist acts. And then there's the cases in the Seventh Circuit, the SAB, that talks about even giving small amounts of money is absolutely material support because it could be combined into more significant amounts of money. And then Ramaji also has found, and Hincapi's also found, any amount of money can be material support, which is why it's critical.
Your point would be, in my penny example, that material doesn't describe the amount of money. It describes what money does for an organization.
Correct, Your
That's a
Honor.
different way of thinking about it.
Exactly, it's whether it promotes,
And so the
sustains, or maintains it.
more tangential what I do is to the organization, the more likely is that it might not be material, like the taxi cab drive for an example.
Correct, and in the penny example, although it does run into all of the problems of all those cases, a penny might not help because somebody might just toss it. That's one reason why I think we're getting rid of pennies is,
Basically,
it goes in a big jar, never to be touched.
Basically, it's hard to escape, at least the result here is what you're really advocating is what you say in your brief is all support, any support. I mean, when you get into the business of a penny being flipped over there, you're not reasonably thinking that's going to foster terrorism. It's just support. And so what Judge Bernard was getting to was, what does material add to this? Because we can get where you're going with a penny and everything else by saying any support. And you can write stuff any way you want to write it. And that's one of the beauty of being an appellate judge. You can write it the most convincing way you want to and call it material and says, well, you gave a penny, and I could see how a penny could be all you needed to get across a bridge to bomb a city over there, and therefore it's material. Or you could probably take a more reasonable approach and say, we are textually looking at this situation here. And we'll say, what is support and what is material support? And then if you add the word terrorism to it, what is material support for terrorism? And then you get into a pity example, you says, well, common sense says that's not going to make a person be a terrorist unless you do have that penny to get you across the bridge example into it, some example like that. Here you have a cook who, I guess, when you get into the facts of it, which really that's kind of where we need to be, you have a cook who he's looking for a job, and as I understand it, he gets a job through help. He doesn't know who he's cooking for. Is that correct? At the beginning, he doesn't have a clue who he's cooking for, does he?
Well, he never said explicitly. He did see the name of the organization was the unknown gunman when he showed up, but that would be an issue on remand for further fact findings.
Right. But, okay, so he's cooking, and he's cooking this particular type of food. Is it Igbo food?
Yes.
That they like, and they like his cooking. And they make him cook just for them. And that's what he's doing. And all of a sudden, it seems like to me, when he does get to a position where, he begins to see this organization kind of has something going on, he wants out of it. He can't get out of this organization. And yet, all he's done is cook. Here's a key thing. He didn't provide the food. He didn't bring anything in. It's what I understand. He just cooks the food for people to eat it who are there. The question there is that material support? The answer is yes, if you see support being anything. Yeah, they had to eat. In order to eat, that made them healthy, and therefore they could commit terrorist activities. Well, that's any support. Or was it support that actually supported a terrorist activity? I mean, that's kind of where we are in making that determination here. I'm not saying it's going one way or the other, but that's where I started with the proposition of how expansive do we look at this statute here in interpreting it? Do we now, because I'm not convinced every time we applied Chevron deference to something that the board was using the same level, because they weren't bound by the same, but once the board made it, we gave it deference. That's the difference.
The important point here, Your Honor, is that the statute doesn't prohibit material support for terrorism. It prohibits material support for people who have committed terrorist acts, may not commit them in the future, prohibits material support to terrorist organizations. It doesn't tie it to those organizations committing terrorist acts. It also prohibits support to individuals who are members of terrorist organizations.
Material support. You keep saying it prohibits support. It prohibits material support.
Prohibits material support to persons who are members of organizations. Again, it doesn't tie it to terrorist activities. But critically,
what would be immaterial support? What would be support that would not be material, that an individual who, I don't know, has some association with, what would be that?
So, for example, the Seventh Circuit in the Khan decision pointed out that perhaps attending rallies of terrorist organizations wouldn't be material support. The board and ACM suggested that general statements.
Do you agree that would be support? I mean, if I showed up at a rally, there's a sense in which I'm supporting that organization.
Well, they actually called it a meeting, Your Honor. I'm sorry, I misspoke there.
Either way, right? But whether it's a meeting or a rally, if I show up, there's a sense in which I'm supporting it, right? Or if I, clap when the group walks past, I'm supporting, but we wouldn't naturally think of that as being like material support, right?
Perhaps not. It would, of course, depend on the facts surrounding it. All of these are fact-specific inquiries.
But you give the example.
But that would be an example.
You show up at a rally. I mean, I mean, you haven't done anything. The question is, if you do something at that rally, if you do stand up with a sign and start jumping up and down, or you start yelling, yeah, yeah, for it, is that material support?
That could be, but that also could fall into what the board talked about in ACM of just being a generalized statement of support. But if it's at a rally for that organization, it certainly seems much more tied
So,
to the
yeah, I mean,
organization.
example of support of saying, you went to a rally, you could have just been walking by there and looked over there and said, a rally. And that's it. And that's your example of what the Congress meant when it added the word material?
Well, that
That it
wouldn't-
has to be something as innocuous and divorced from the situation that you are sitting there, you could be, sounds like to me, you're analogizing as though you're in a building across the street with some binoculars looking at it. And that's not support. I gotta agree with that. But
Right.
that's not the same. It's no different than you walking down and standing there and just looking. It's just got yourself closer. The closeness is still there.
I don't think that would be material
But
support
to
either.
actually, the question I'm asking is, what is an example of, that makes it immaterial support? Support, because that's not support. That's not support at all, what you just said. Standing up in a crowd is not support at all. What is support that is material? So what is an example of when support is immaterial?
Again, I have to go back to what the board said, is that, I'm sorry, can I answer this question?
Please,
Your Honor?
please.
I have to go back to what the board said, which is that material support is when it promotes, sustains, and retains the organization. If it doesn't do that, it can't be material support. And critically, Congress did set up, it's extraordinarily broad. Courts have acknowledged over and over again it's extraordinarily broad. Some have called it overbroad. Critically, Congress set up this exemption scheme that includes de minimis material support, that includes support under duress. It acknowledged this in 2008 when it required reports on duress exemptions to it. So
Is there a
it,
de minimis, does the phrase de minimis appear in the statute?
no, Your Honor. But there's an
What did
exemption.
you mean
for-
by that? I heard that too. You said Congress created a de minimis material support exception?
It created the broad exemptions. DHS created, I'm sorry, I'm out of time, so I may have
No, you're
spoken too
good, you're
quickly. But Congress created this broad exemption system that has been used extensively by DHS. And one of the things they've exempted is duress. Actually, there have been a number of different kinds of duress exemptions. There have exemptions for de minimis or minimal material support, both of which this particular petitioner might have been eligible for, but he also needed to be eligible for the underlying relief, and there were 3 reasons that he wasn't. So there was no exemption available to him here. So even if he were to prevail, the agency would still have to consider his underlying eligibility. All right, I
Thank
see
you
I'm-
very much.
I'm very out of
Appreciate
time.
that.
Thank you.
Mr. Kimmel, you got a few minutes.
Thank you, Your Honor. And if I may just briefly address the materiality and then address the Loverbright questions in just a second. The court is getting to the core problem with the government's definitions here with support and material support. The government has repeatedly said, and as they said in their brief, that support means something that promotes, maintains, or sustains the organization.
So why wouldn't I use as the example that if I want to write letters to the editor that support Hamas, right, or some other organization, I might be writing those letters, but I thought what we've suggested is where they are like not coordinated, right? I'm not doing it at their behest. I'm not doing it to raise funds for them. I'm just expressing my support for their terrorist goals. That wouldn't be material support. It's plainly support. Like I'm writing a letter to the editor in support. But we wouldn't call that in any sense material support. And Supreme Court, maybe it's not the Supreme Court, maybe HLP says this, but maybe it's elsewhere, that wouldn't be material support because it's like independent advocacy.
So, Your Honor, that may be the colloquial understanding of support, but that's not the definition that the government has provided for support, which is something that maintains and sustains the organization. That definition, support that rises to a level of maintaining and sustaining an organization, also rises to the government's level of something that has a
I take the
logical-
government to be reading material support sort of as a phrase, not to sort of try to break it out into 2 pieces, right? And I take them to be saying material support means that, not, right, writing in support or, showing up knowingly, has to be knowingly, you can't just stumble there, but knowingly showing up in support of a rally, that might be support in the sense that that word used in isolation might be. But nobody would think of that as providing material support to that organization, absent some coordination or absent some action, raising funds, doing something beyond just advocacy, right? I mean, it seems like to me that's sort of what HLP is telling us that this distinction is.
But both words have to have some meaning, and that's to go, and as we point out in our brief, the Supreme Court in Kungis, in the INA context, has held that materiality, when the word is or isn't included, changes the definition, and it changes the threshold. So it's not a phrase. Both words have to have some meaning here, Your Honor, and if it doesn't rise to the definition of support that the government has provided, something that maintains and sustains the organization, then it doesn't rise to the level of material support. Those are essentially coterminous terms. The support is sitting at the level of where there's no gap. There's nothing that falls in that
But
gap
we're just
under those
defining,
definitions.
but our job is just to define them, right? Like whether the government
Sure.
says it or not, like doesn't matter anymore. This is the point of the earlier conversation, right? So the question is like, what do these mean together? And it seems to me the natural meaning of the word support would include my like independent advocacy for an organization, even though like we wouldn't naturally think of that as providing material support in the sense that it's not actually like lending them aid.
I understand. So that distinction, but that's essentially saying that the difference between support and material support is speech. I mean, this is your advocacy, but that isn't, that definition.
That's one example, right? We were trying to talk about examples. I think we can talk about the taxi cab as maybe a different example, but like this seems like the paradigmatic example that HLP is focused on, at least my recollection of HLP, to be fair. That this is the example that they're focused on as not what is at issue.
It may, but that distinction, that would be to simply say that advocacy kind of support, First Amendment type of support is what Congress meant when it included the word material. It would be a very inconsistent way that the word material is used across federal law and inconsistent with the definitions. To take those definitions that are used after, not the definitions, sorry, the examples that were used after, Your Honor, of weapons and explosives and funds are the type of thing that go to our definition, which is significance and relevance, not speech and advocacy. Those are
Some of the words do, but not all of them, right?
But none of them have to do with advocacy, Your Honor. None of them indicate
That's right,
an advocacy distinction. Or that
because
there
they're
is-
not included. That's the sort of point, right? Is that like, they don't include advocacy because it's not material support.
They don't include advocacy because it's not support either, Your Honor. That's the distinction we're making, is that advocacy support doesn't satisfy that definition. Or that sort of First Amendment distinction there isn't the distinction between material and support, or at least nowhere else in the statutory examples, nowhere else that would change that sort of distinction, Your Honor. And to take one other. And to take that example, Your Honor,
it's a matter of focusing on the statute Congress has done. And, when we get down to it, Congress gave some stock examples of what is support. I mean, we say safe house, things that are there, the actual transportation, communications, lands, funds. They didn't get into business like, did you mow the grass? Or did you cook? Or did you do things like that? That's what the court has done. We've moved this bar by using this term, taking this term support alone. It seems to me you don't even need material in it. I mean, one part of it says other material financial support. It could have just said financial support, but it said material financial support on it. And, we as the court, as I say, we can read these things how we want to. We could say, well, we're going to make that support. And just when we write an opinion, I promise you it's going to be support. Whether Congress wrote it or not, or even intended, I don't think anyone here probably thinks Congress was thinking about a guy who goes over and just cooks a meal for some people who are sitting there is what they sat down and wrote a statute about here. They wrote a statute that deals with people who actively are participating in supporting a terrorist organization, and not people like your client in this instance, who it appears from the facts here, I mean, there are other things here to consider. I'm not going to get into that aspect of it, but at least in terms of this act of it here, that doesn't appear to rise from the text of this statute at all. I mean, that's something we've added into, and the more we talk ourselves into it, yeah, we can make support material, just by adding examples and coming up with all kinds of analogies for things that really just not here. And I mean, it's a question we just have to deal with one way or the other here.
Yes, Your Honor, if I may, just briefly.
Briefly.
Yes, Your Honor, just briefly, we wholeheartedly agree that Ms. Rosarumba's forced cooking did not rise to that level, did not push the support above a materiality threshold. Thank you, Your Honors.
All right, we want to thank both counsel, particularly want to thank you, Mr. Kimball, for having served here in a pro bono status. To do that helps us to do the work of this court, because we have many cases in which we have to rely upon counsel to provide services to clients of this sort. Otherwise, it'd be difficult to get representation. And of course, Mr. Stone, you ably represented your client as well. So we'll come down and greet counsel and we'll proceed to the last case. To the final case of the day, Gray Media Group versus Heather Loveridge. We will hear from the appellate's counsel. Ms. Russell? Didn't see anybody jumping from the bench there. I was wondering what's going on here.
All right. May it please the court. My name is Lauren Russell. I'm here on behalf of Appellant Gray Media Group, here with my colleague Caitlin Gurney. This appeal arises from a motion pursuant to the public right of access to court filings in a case that concerns a friendly fire incident. Transparency is important in every case, but here
You want to get the videos of this matter here, at least two of them. You went to the district court. District court says, I don't have jurisdiction because there's a pending interlocutory appeal by Loveridge to the Court of Appeals. That sounds correct. There's no longer a pending interlocutory appeal before the Court of Appeals. So why can't you just ask the district court, says you now have jurisdiction?
Well, Your Honor, yes, so I would like to start with the court's ruling denying the motion to intervene in the first instance. So the WBTV's request was ultimately a motion to intervene
Now,
for
the
the
denial of
limited.
the motion to intervene, the basis of that was?
It's for the purpose of asking that the
I mean, the legal
court
basis
filings,
for denying it that the court relied upon,
it was for lack of subject matter jurisdiction.
because there was an interlocutory appeal here.
That's right.
There's no longer an interlocutory appeal here.
That's right. And
So where are you starting?
So I am starting at the district court's order that's on appeal. And so, Your Honor, I agree that there's not really a question right now. If the district court were to hear this motion, I expect that
In other
he
words,
would not
you
have.
would agree the district court now has jurisdiction.
I agree, but I also assert that the court had jurisdiction in the first instance.
Did you file effectively two motions below, a motion to intervene and a motion to unseal?
Yes, it was a motion to intervene for the purpose of, limited purpose of asking that the video exhibits be unsealed.
The court seemed to treat it as two separate motions, and the local rules provide that you don't have to intervene. This is Rule 6.1H. You don't have to intervene in order to move to unseal something. Like, naturally, it makes more sense to move to unseal things without intervening, because if you intervene, you become a party, and like, you don't want to be a party, right? You're not going to appear at trial. You don't want to like argue summary judgment. You only want a motion to unseal.
I agree,
Right?
yes.
Okay, and so if you do that, and I accept for a minute that the district court did lack jurisdiction to decide the motion to intervene, but that doesn't mean it lacked jurisdiction to decide the motion to unseal, which didn't require intervention to make, because the local rules make clear you can just file the motion, right? Is that not the way to understand what the court did? The court actually did lack jurisdiction to allow you to intervene while the appeal was pending. But that doesn't mean that it lacked jurisdiction to decide the motion to unseal.
Your Honor, well, at bottom, ultimately, we really just want to exercise our right and ask that the court unseal court records. And the procedural mechanism that we used was, I believe we cited Rule 6.1 as well. But, you know, I represent the press around the country in seeking access to court records and filings, and typically, the federal rules, what they provide is, you know, the right to intervene.
But how, can you help me with that a little bit? Because I confess that doesn't make any sense to me. Because when I look at the intervention rules, I don't see how a good faith effort could ever be made by a media organization to like satisfy the rules, right? Like, you don't share a like common, you know, issue of law or fact to be decided by the court. It just is an odd fit, right? And if you are allowed to intervene, you are now a party, which means presumably you got to respond to every motion that's filed. If there's a trial, they got to set up a table for you, right? You're now a party to the litigation. That doesn't make sense. This is why it seems like to me the perfect mechanism is Rule 6.1H here, which is exactly what the district court allows, which is you can just file a motion to unseal improperly sealed records. That seems perfectly sensible. There's no reason for you to be a party to this litigation. I don't think you want to be a party to the litigation, right? That's not what your job is.
You're exactly right. And, Your Honor, and to that point, so the motion to intervene, I understand that's just the step that the courts have instructed, and we've understood under the federal rules is a first step that we must take. But at bottom, we are here because we want to exercise our right to request access to court records.
Well, part of it is, part of it that we're dealing with, and Judge Richardson pointed out the nature of the two types of motion, the intervention motion and the unsealing. That's not what the district court dealt with. It just dealt with one motion and said, I don't have jurisdiction over, which, even if he did have jurisdiction, he just didn't acknowledge he had jurisdiction over the unsealing of it. My question is why not just go back to the district court and says, yes, you now have jurisdiction, or is that something we can just direct you now to go back? You got jurisdiction, and we want the district court to evaluate whether this should be unsealed and whether you need a motion to intervene, even though I don't know if intervention ties you in so much, because you can intervene for a limited purpose to some extent. I think you can. And maybe as a media group, you probably would love to be involved in a trial if they would let you do that. That's probably not going to happen. But, you know, that was where that was going. But Judge Berner has a question.
Well, I did want to point out that the district court did reach an alternative ruling saying that even if it had jurisdiction, it found no common law or First Amendment right to access the video exhibits. So is your position then you're appealing the alternative ruling as well, which I'm not sure we have?
Yes.
How we treat that at this point, given that you're not a party to the litigation?
Yes, Your Honor. So I'll start with the motion to intervene issue. And Stone versus University of Maryland is a case that was before this court where it was slightly different in that the media interveners moved in the Fourth Circuit to unseal the record on appeal. But, and And before the proposed intervener's motion was decided, the court actually had already remanded the case. So similar to this case, but this court actually stated that the right of access to judicial records and documents is independent to the disposition of the merits of the case. And that's actually been relied on in other, this court has not seen this particular issue of the district court denying a motion to intervene for the limited purpose of seeking to unseal records. But other circuits have looked to Stone and actually relied on it in deciding motions to intervene for the purpose of unsealing when there was an appeal on the merits pending. And
Well, it seems as though you go, I mean, the basis of a motion to unseal, it seems like you ought to have some involvement in the trial. I can see why the intervention comes up, because basically you're saying, I belong here, now I want to say unseal, other than I didn't walk off the street. Here, anybody could just walk off the street and say, here, I want you to unseal this motion, unseal this right now. So I'm beginning to see a reason why you have an intervention in it, because it establishes some basis for you to file a motion to unseal. And you know, but the ultimate question that does exist is, even with that, if the motion is denied by the court, then that too, is that interlocutory? Because you're not a party to it. You didn't allow you to, there. So how do we get it? It's strange to me, because you got this animal out here, the motion to unseal, which the media has done. There's special laws that are dealing with that. Go in, says, I want you to unseal the record. Nope, appeal it. And then, but you're not part of the case. So that's not interlocutory, I guess, in that sense, but it is, because that's the case, and it's not a resolution of anything, but it is a final judgment for you.
right, that's right. And
What about mandamus?
yes, Your Honor.
Which someone has written on this court about. What, is there any applicability here?
Yes, there is an applicability, yes. So yes, Judge Richardson has written about the option of mandamus, where it's the question is concerning a motion to unseal, like the news outlets. No matter what the status is on standing on, there's the option of non-party appellate standing, which is if the non-party possessed an interest in the cause litigated before district court and
But it needed to actively have participated in the litigation below, isn't that right?
Yes, Your Honor. And we participated as much as we could as a non-party. We moved to intervene as soon as we became aware of the court filings under seal and asked that they be unsealed. And we are as privy to the record as we can be, given that the records are under seal. And so our position, our standing under non-party appellate standing is akin to that in Company Doe. But ultimately, though, the court need not dwell on that, because in Oberg, the court said actually a petition for mandamus is even a preferred mechanism to consider a public right of access to court records. So, and to address Judge Berger's suggestion, ultimately, we are here and hope to have these records unsealed as promptly as possible. And this court has stated before that each passing day may constitute a new and cognizable infringement where the public is denied access to ongoing court records and proceedings.
What is the remedy you want us to offer here today? I mean, I know ultimately you'd like to go and, let's just say, go get the videos and show them to you, but there's a trial judge involved in here, and the record is really, really, I mean, it's just not as complete as we want. I really don't like the word mandamus for a trial judge, and I'm just wondering, at the end of the day, what is it you want? And is it that would you be amenable to a remand to the trial judge to consider these motions, including the unseal, in light of the case law that exists on how one goes about to determine whether or not a record should be unsealed, as opposed to us just on this back and forth trying to figure out, should you get this? Sort of playing trial judge, in my opinion, but you see where I'm going? A simple remand, does that not give you some measure of relief here?
Your Honor, I would ask that you remand with instructions that the court order the court records be unsealed. The record,
I just want to check to make sure you're being clear. You said the court records, there's like a ton of stuff that's under seal here. When
Yes.
you say court records there, you're only referring to the records that you sought to be unsealed below. That is the videos.
that's right.
Okay.
The video exhibits. And
Because
that
there
is,
are other things that you have not sought to be unsealed, and we would not be addressing in any sense in this case.
that's right. But the record as to the video exhibits is complete. We moved to unseal, and which then Loveridge responded, and it was her burden to demonstrate that the First Amendment right of access, the presumption, had been overcome. She did so, and to do so, she must assert a compelling government interest, and that that sealing is necessary and
And she did here. She asserted such an interest in a fair trial and provided argument to the district court. And presumably, your position is, if she's got something new now, it's too late, right? That was the opportunity she had, and so to remand it would be to tell the parties that they just get another bite at the apple. They had an opportunity to assert their interest, and that interest either rises or falls.
That's exactly right. Yes, she conclusively asserted her fair right to trial would be prejudiced. But ultimately, this court has found, and the Supreme Court has found, that voir dire is the preferable mechanism to protect against fair trial concerns when it's being weighed against the First Amendment right of access to court records.
I understand this is an impossible question for you, but it's similarly impossible for me, so I'm going to ask you. So when I look at the record below, the various filings that are made by the parties here, they describe these videos in like a fair bit of detail, right? They talk about the various angles. In the record, the unsealed record includes screenshots from the same videos that are under seal. From your perspective, having not seen the videos, I understand is hard. What is it that you're interested in seeing that's not already been revealed by the descriptions and the screenshots that are in the public record? Like, what are you looking for? Which is another way of saying, like, what are they trying to hide?
Your Honor, and I'll briefly address this, but so the contents of the video have been hotly contested, and the core issue here is, did Officer Loveridge know that Officer Belton was an officer when she shot him? And they, here, we have descriptions of the videos, we have screenshots, but it's up to the public. They have a right to see for themselves exactly what happened that day. And I would proffer that because there's so much already in the, public court record, that Loveridge doesn't have a great basis for asserting that her right to fair trial would be prejudiced by additional information. All right. Thank you, Your Honor.
All right, thank you. Mr. Batter, we'll hear from you.
Good morning, and may it please the court. Stephen Bader from Cranfield, Sumner, and Raleigh here on behalf of the appellee, Heather Loveridge. I want to start with the mandamus issue, and I want to correct something in my brief related to the Seattle Times versus Reinhart decision. And to do that, I kind of want to set the stage with these 4 videos.
But make sure we are talking about the same thing. As Judge Richards has pointed out, 2 motions, motion to intervene, motion to unseal. Judge Berner pointed out there's an alternative reasoning here. One is that no jurisdiction, subject matter jurisdiction on the intervention. We probably can all agree to that, at least while that was being appealed. On the unsealing, that's the problematic part of this now. And it seems to me, as Judge Richards has alluded to, is that maybe we can make this decision ourselves and say, just do this, or we could remand maybe you see another alternative is simply just to affirm what it did below. That may be where you're going, but I'm just setting this up so you see kind of where it looks like the positions are with instructions to the district court, because he may not have considered things like the public interest. He may not have considered the improper purpose. He may not have looked at the fair trial weight or the less restrictive alternatives here. And while we could do it, I'm not sure this record allows us to, we can do what we could, I should say it. I'm not sure we should under this record. Alternatively, it could be your position that we just affirm his denial, and I assume that's where you're going with this.
There's a lot of procedural machinations here, so I'll work through a couple and then try to address the comment or my issue, my mistake in the brief, rather. I think what this court can do is any number of things. I think number one, you could affirm and say there was no jurisdiction to deal with the motion at the time it was filed. You could affirm on that ground. You could then deny, you could treat this appeal as a petition for writ of mandamus and deny the petition. I don't believe that that outcome would preclude Gray Media from going back to the district court now that it has jurisdiction.
Even in your world, the basis for denying the petition for mandamus on the motion to unseal would be what? That the First Amendment doesn't apply, or that the arguments you made that were adopted by the district court suffice to establish a compelling interest and sufficient tailoring to warrant the sealing?
I think the latter is one argument, but I want
Are
to
you
make
making both arguments? Do you, as you're standing here today, do you think the First Amendment right of access fails to apply to the videos?
I think it likely applies. I think the question is whether mandamus is the avenue to get it at this juncture, and that's where I want to get to my issue, my error with Seattle Times. These 4 videos were held by the North Carolina State Bureau of Investigation. These were not videos that were held by the parties. And that's important because for the parties to get these videos, they had to get a consent protective order that was issued by a North Carolina Superior Court. My error in discussing Reinhardt is that that protective order wouldn't implicate the First Amendment. I think that that's correct. That probably does not carry to the summary judgment filings. And so to the extent my brief misstates that, and my friend has pointed that out, I want to make sure that I'm clear in correcting that error. However, in Oberg, the petition for, to carry the burden of mandamus, the party must show first it has no other adequate means to attain the relief it desires. Now, I want to focus on that for a minute, because these videos and what's cited in the briefing were produced pursuant to North Carolina General Statute 132-1.4a. That is a statute that governs custodial law enforcement agency recordings in the state of North Carolina.
Okay, wait a minute, just so I understand where this argument's going. You're saying that First Amendment protected court filings cannot be unsealed if you could get them somewhere else unrelated to the court proceeding. So in other words, when you put it in play by attaching it to a summary judgment motion, you can avoid unsealing that because there's some statutory mechanism by which it could, in theory, be obtained from somebody else.
Not exactly. Not exactly. I'm saying that in treating this petition as a petition for writ of mandamus, the first criteria that Gray Media needs to satisfy is that they can't get this information anywhere else.
Wait.
They have
is that what mandamus says, right? Please give me the case that says that the first part of mandamus is that they can't get the information from somewhere else, as opposed to they can't seek relief in any other way, right? The relief that's being referred to, right, is the action taken by the district court, right? The refusal to unseal. It's not relief in the meta sense that whether they can go get them by FOIA or something, right? Mandamus doesn't require the inability to get some relief through some other means. The relief relates to the district court's decision. I mean, I've never heard of mandamus suggesting that we were going to seek mandamus to the district court and that it is not permitted because in some other way outside of the action, you could, through a back door, get an indirect relief from what the district court did.
Well, I don't think it's getting it through a back door. I mean, this is these videos are
It will not be getting the filings in the court. What you're saying is they cannot get the filings in the court. They can go to somebody else and get what they might presume are the filings in the court, but they can't actually get them from the court.
Is this an argument that was made in your brief, or is this a new argument?
This is, I think probably the most fair answer is no, other than we did cite the statute, and that the statute is what dictated the release of these particular videos. But I think the point is, if the relief that is sought here is the release of these 4 videos, and those 4 videos were given to the parties to this case via a protective order, this isn't the only mechanism available for.
But the point being here really is that this is a non-party, and mandamus is a means by which under Oberg you could get this. But as Judge Richardson, I think he's alluding to, is the fact that that's a pretty limited determination. It's Article 3 standing, and it's Rule 21, Rule 21A compliance, which they seem to meet that here, which is Rule 21A, simply dealing with filing, servicing, docketing, and that sort of thing. So, I mean, that's different. And I don't know if that additional requirement you've added in there is anywhere I see in the mandamus, at least from procedural perspective.
Well, then I think the court can look at it like this. I mean, if the court believes that, in fact, Gray Media has no other adequate means, then the question becomes the restrictions or the determinations made by the district court that Ms. Loveridge.
They have another adequate, what is the other adequate means they have to obtain the filings in this case that are under seal?
As a non-party.
What other means do they have to get the filings?
To obtain the filings themselves, there would not be any other means. I would agree with that. To obtain the video, which I think is what the initial argument has been, there are other means.
As a non-party.
Right. There's at least 2. They can petition the Superior Court via the mechanism that the General Assembly has set up for custodians to release these records, or, given that this case is now back to the district court, they could file a motion to unseal there.
And neither of those arguments were made in your brief in response to the request for mandamus.
Well, the second argument didn't exist at the time, because at that point, the merits case was still up before this court, and so the jurisdiction issue was still.
But the argument that they could seek these videos in another.
Right.
Can you take me to the arguments made below? As I understand it, when I look at the filings in response to the motion to unseal, I understand the motion to intervene piece, but the motion to unseal, it's a single sentence that says the publicizing the video exhibits would impair the ability to receive a fair trial before an impartial jury. There's no explanation of that. And I take Judge Wynn's point perhaps to be that we should send it back to the district court judge so that you could get a second bite at explaining what you could possibly mean by that, given all of the discussions about what's in these videos that already exist in the public sphere. Is there anywhere else that you've tried to explain why this additional information, the actual videos themselves, would impair the trial rights? I mean, that you make the conclusory statement here. In the brief, you say the same thing. It would impair the trial rights. Like, that can't be sufficient, right? So do you have something that you think you haven't argued before that you should be entitled to argue on remand as to why that's true?
Well, I would say this. That's been the argument that's been advanced. That's what the district court also
Well, that's
concluded.
the conclusion. There's not actually an argument about it, right? The conclusion you've given is it would impair the fair trial right. There's no argument about it, right? I actually have no idea why you think it would impair the fair trial right, because all I have is the conclusion. And so what I'm asking is, are there arguments about that that you haven't made yet that you think you should be able to make in sort of a remand posture?
Well, I think that the practical piece of the remand posture is the fact that this case is now back before the district court and is again headed towards trial. It's currently set for trial on June 16th, so next month already. Now, to be clear. Whether it gets tried or not, I don't know, but that's when it's set. And so if this matter is remanded to the district.
Is that realistic, given the order of this court?
I don't know the answer to that. I only know the setting. I know that's the setting on my calendar. And at the district court right now is reconsidering, or is taking briefing on, whether the what the clearly established right would be in reviewing that qualified immunity issue. I don't know.
It just seems like we're making a complicated matter out of something that can probably be resolved at the district court level under the local rule 6.1H, which deals with non-party type motions of this sort. Because when you say the district court made an alternate determination, it surely did not comply with the case law that says that he ought to evaluate the public interest in it, whether there was an improper purpose here, whether the fair right of trial is being implicated, whether there's alternative means. Those are things district courts do. And it just seems, at the end of the day, we could bounce this thing around and say mandamus and go and do these things or do it ourselves. But I think what we're here to do is determine, this is not about the trial itself, by the way. This has nothing to do with Officer Belton getting shot and all of the other stuff. This is about public access to a video, for which it does not appear to me from the record that the district court made a full determination of whether this should be properly unsealed. We're here in a situation because we're dealing with a non-party situation. What the motion to intervene would have made it a party so that we can then deal with this stuff. But we're still dealing with non-party who's trying to do these things. And we do have the North Carolina statutes in terms of what's here. There's difference between unsealing and releasing. All they're seeking to do is unseal, not release. That's a different type of statute you're dealing with there. But would you be disagreeable to sending it back to the district court to properly evaluate in light of our case law, the Charlotte case that deals with the night media, the whole bit, and make that determination of whether this should be sealed, unsealed, not released, unsealed?
No, I mean, that was our final argument, is if this court is inclined to believe the mandamus relief is available, then the relief, and it's discussed in Stone, it's discussed in
You guys could get
Rushford.
together when this is over and decide, why don't we go back and see if we can't do this? I mean, other than the jurisdictional aspect of it, but the basis of that is no longer there. We don't often say you can just go back and handle something, but it really does seem like this could be handled without making a major case out of a major issue, out of a case that it really has a major issue in it. This is not it. This is dealing with the collateral issues of whether the public has a right to these unsealed records. And there's a way in which the district court has to go through and make those kind of determinations. I don't see it here to do that, but it may well exist. And at some point, you may agree to do it or not agree to it. But there's a bigger case here that's going to be dealt with than the unsealing this record.
I certainly agree with that, and I guess I would just say that was the last point we made in our brief, which is that.
I thought, well, at least the first argument you said is the district court actually did this, right? Because the district court found that unsealing the video exhibits would impede Loveridge's ability to receive a fair trial before an impartial jury. And this qualified First Amendment right is overcome, right? And so it requires that they remain sealed. I mean, it's done the very balancing. Right? That this is a compelling interest. He says Loveridge's right to a fair trial is a compelling interest that outweighs the media and plaintiffs' First Amendment and common law interest in unsealing the video exhibits. See Stone. I mean, it's done it.
Right.
I mean, it didn't give us any facts or it didn't provide any reasons. It's just a series of conclusions. But it says that it's done it, and so it's a little odd for us to say, yeah, just go do it again, because you didn't do it very well.
I think really that's an alternate argument. That's the last argument we made.
What about the point that he applied the wrong burden of proof?
I don't believe that he did apply the wrong burden.
There's an argument he did. It does appear to be that way. The case law places it in a different position on this. I'm not sure the articulation of what those factors that would support the public interest in disclosure is as clear And Judge Richardson's articulated them quite well, but I think he's articulated much better than the district court did. Either way, at the end of the day, either we do it or we send it back. And I don't know if it's a second bite. I don't know what you're biting on because you got a denial. The bite would come from the other side or not. I don't think it's something we ought to be tied up too much in if we can get a jurist to make a determination in light of this. Then either he unseals them or not. Comes to maybe judicial economy, as Judge Richardson says, maybe we should do it. But that's something upon looking at it. I'm not saying I made up my mind or any others made a mind on it. I'm just saying that's something we're reflecting on here. But that does seem to be a way to handle this without, this court having too much to do with it.
And I agree, and that's why that was the last argument that we made.
Can I ask you a merits question about the right to a fair trial, which doesn't seem to have been really addressed below other than the conclusory statement that was made? I do question why voir dire wouldn't resolve the concerns about the right to the fair trial.
I think the best I can answer that question is that the district court was not persuaded that it would to such a degree that it addressed it. I think what
I apologize. You said, what is the it in that sentence? I just didn't hear the question. I'm sorry.
The question well, you can go ahead.
What Judge Byrne was asking about was voir dire.
Oh,
whether that would.
Thank you.
And,
all right. I'm sorry.
And I think the best I can answer that question is that if the district court's finding of the compelling interest did not find that that was an appropriate lesser restraint. To be fair, it didn't address it one way or the other. I'm reluctant to get in the district court's head and try to decide why he did it that way. I would just say from a very practical standpoint, I think my friend has sort of outlined at least one of the issues in this case, which is whether Officer Loveridge, who is a uniformed officer that was standing outside of this garage, could identify a plainclothes officer as an officer after a shooting melee erupted and he's coming back out of the garage. Describing it and even hearing myself describe it is not the same thing as actually seeing what is depicted on those videos. And so if the district court in its gatekeeping function believes that that's going to impair Loveridge's right to a fair trial, that would be an appropriate determination left to the district court. And if the district court believes that voir dire and asking people or potential jurors whether they've seen it is not adequate, that would again be a determination, at least from our standpoint, that would be best left to the district court.
Well, it just seems to me that in every police shooting case where there's video evidence, there would be a request from the police to seal the video so it wouldn't become public. And that if this were the rule, then video from police shooting cases would always be under seal.
Well, and I'm not sure this will be responsive to your thought process, Judge, but I'm not arguing for a blanket rule. I mean, I'm just simply stating that what happened in this case is the parties followed North Carolina law as far as getting these records released from the custodian. There was a protective order that was put in place, and they then filed under seal. That's what happened here.
But the only argument that was made, or the only assertion that was made, is that releasing the video would somehow interfere with the right to a fair trial, with no argument really in addition to that. And so, in essence, your client is asking for a blanket rule.
I guess I disagree with that in the sense that we're just really responding to the request here. I mean, I think fundamentally, and it's reflected in this court's opinion in the underlying case, I mean, the issue here is going to be whether, what rights Officer Belton in plain clothes had as he was trying to scurry out from this melee and whether he could have been identified. Certainly, I could articulate a potential here that people watching that video, potential jurors watching that video, are going to look at that and say, yeah, I could see it, or from this vantage point, I could see it, and that could prejudice my client's ability to get a fair trial on the issues. What I would ask in conclusion
This is just a question of clarification insofar as, because I asked you about the burden of proof. Is it the burden on the media to show that there would be a monumental public interest in it, or is the burden on you to show that there is no such thing? as
think-
a public interest in the video exhibits, that the public interest, who has that burden?
If it's a First Amendment right, it is my burden as the party resisting the motion to unseal to show that that compelling interest would outweigh. And that's what
Well, then, when the district court says that the TV, the media has not shown why at this late date there would be such a monumental public interest in the video exhibits, why is he not putting the burden incorrectly on the media?
I'd have to look back through the order, but I believe later on, what the district court order reflects is that Loveridge has demonstrated a compelling interest that would outweigh WBTV's request to unseal. I
It's
agree.
describing the nature of their interest, right? That
Right.
if the balancing would look different if they had a super high public interest, right? He does the balancing in part based on the suggestion that the public's interest isn't like super high.
Right, I
I'm
think,
only speaking to the burden of proof, and when you say the TV station has not shown why at this late date there is such an interest, I don't know what the balancing is. That's pretty straightforward statement. Again, going to how do we view what the trial judge did? And it doesn't mean it's the end of the case. I mean, if we want to push it to make this the end, we could. You know, I don't know if it has to be a monumental public interest, first of all, because the public has a right. It's a right, period. So I don't know if it has to be a monumental public interest, even that. You know, it was all done in a single motion, and basically with the subject matter, jurisdiction matter being sort of overshadowing, then this alternative thing that now has become the focus of things here, and there's just a lot packed into this case. And I say, I think this can be resolved without us having to write up something on it, but we'll see.
I appreciate this court's dialogue this morning. I'm well over. I think there's a lot of different ways the court can handle this, and on behalf of Ms. Loveridge, we appreciate the court's time. Thank you.
All right. Thank you, Mr. Bedell. Ms. Russell, you have a few minutes.
Thank you. So WBTV filed its motion in district court 14 months ago, and we are still waiting to have access to these video exhibits. My opponent's argument is really just, at bottom, arguments for further delay on procedural bases. There are, but this court has said before that each passing day that the public is not allowed access to court records that it is entitled to access and is an additional infringement. Here we have a complete record and on the arguments from the court below, and this court has full discretion to review the decision de novo and determine whether the conclusory assertion of a right to fair trial can overcome a First Amendment presumption of right of access to these video exhibits.
Do you agree that there is at least the possibility of a case where the right of fair trial would overcome the First Amendment right of access to a given video?
Yes.
But I assume you don't agree that there's like a categorical rule in any high-profile matter that the right of the fair trial necessarily overcomes it.
That's right. And right, that is essentially what my opponent asked for, is a categorical rule that these videos, like of this nature, should be under seal. And
What do you say in response to the potential argument, maybe one that hadn't been made precisely, but is that, you know, the district court judge has seen these videos. I have not seen these videos. They weren't filed in this case. You couldn't file them because you don't have them. And your colleague did not file them under seal. But the district court has seen the videos. And so that we ought to give deference to the sort of judgment that's being made that these must be really bad. I mean, district court doesn't say this exactly, but they must be really bad if the right to fair trial overcomes the First Amendment here.
well, I do not believe that you need to look at the videos because it's plaintiff's burden to demonstrate that there is something special about these videos. This is one of those unusual circumstances where sealing is necessary. And my Loveridge has not done that. And ultimately, there is significant public interest in these videos. It's that's not something that is truly, that needs to be weighed. But here, we have law enforcement officers where there was a horrible accident on the job, resulting in work that resulted in one of them being shot many times. And these law enforcement officers are subject to public scrutiny. So we have not only the interest in making sure that we can monitor our court dockets, the public has that interest, but they also have that additional interest in knowing exactly what happened that day and seeing for themselves directly what happened that day. And I do want to touch on the procedural questions. And so I believe that the court below misread Company Doe on denying the motion to intervene, because there is the collateral rule exception where when a motion is filed and it has no bearing on the merits, the court can still decide that case. And in Company Doe, the issue was not collateral. There, the district court had not ruled on a motion to intervene. The proposed interveners appealed the constructive denial, and then at that point, the district court denied the motion to intervene. So yes, that was two courts.
Can you address FTC versus Lynn, which is the later Fourth Circuit case that sort of, you might say, also misconstrues Company Doe in the same way and applies this bar on deciding motions to intervene when an appeal takes place in a more categorical way?
Well, Your Honor, I don't think it's necessarily fair to fully address that because it was not a motion to intervene for the limited purpose of seeking to unseal. It was an intervener who truly wanted to be involved in the case for a longer time.
I get that the court could have adopted a narrower rule, but it seems to just say categorically, citing to Company Doe, that if it's an appeal, the motion to intervene is lacking. I'm not saying that that's the right reading of Company Doe, but it does seem to be our precedent, and you were with us early. We have a tendency here to follow our precedent sort of no matter what.
Your Honor, and I believe I'll run out of time, but I'll address this briefly.
Great.
So I would
You take as much time as Judge Richardson needs you to answer that question.
I need lots to understand. So.
Maybe not that much.
Well, Your Honor, if that is how this court wants to interpret FTC versus Lynn, then I would ask that you make an exception to that rule and that court's holding and say that when it's a motion to intervene for the limited purpose of seeking unsealing, then the court may address that. And I just want to also add that not every court has a local rule like Rule 6.1. And I frankly, and it is awkward to be an intervener or just a non-party trying to figure out how to ask the court to unseal records. And how we get on the docket, for the most part, to even be permitted to file is by filing as a proposed intervener. So I realize that it's procedurally a little complicated, but I hope that Your Honors may consider the motion to seal and reverse and remand with instructions that the video exhibits be unsealed immediately.
All right, we thank both of you for your arguments. I'll ask the clerk to adjourn court for today. We'll come down and greet counsel afterwards.